Good morning, this is your Kelso Report for Monday, February 6th, and I'm your host, Clark Kelso. We start out with arbitration as our topic. Now, when in-house counsel tries to become a whistleblower, you know you are in for a wild ride. In Biller versus Toyota Motor Corporation, the dispute between the former employer and former in-house counsel turned ugly when the company alleged the former in-house lawyer had improperly taken confidential and privileged documents with him on his way out. After one round of litigation, the parties settled their claims. But then, an issue about whether the former counsel breached the settlement agreement arose, and pursuant to an arbitration clause, the case landed before an arbitrator. When the dust settled, the employer won the arbitration, and the former employee tried to challenge the arbitration award in court. Well, as you all know, the grounds for reversing an arbitration award are extremely narrow, and there is almost no review on the merits. The Ninth Circuit affirmed the district court's decision to reject the claims of errors, and it affirmed the award and injunction, barring the former in-house counsel from continuing to disclose confidential information and documents he had received while serving as counsel to Toyota. He lost the round in arbitration. It'll be interesting to see if the state bar ends up picking up this matter. Next, we turn to an environmental law case arising under NEPA. At the end of the Clinton administration in 2001, the Forest Service issued a final environmental impact statement recommending amendments to the Sierra Nevada Forest Plan. The amendments were intended to conserve and repair the aquatic and riparian ecosystems. After President Bush came into office, the 2001 amendments were reviewed. 3 years later, the service issued a supplemental environmental impact statement that adopted, of course, a very different approach to forest management. The 2004 EIR was challenged for failing to undertake a hard look at the impact of the changes on fish in the Sierra Mountain streams and rivers. In Pacific Rivers Council versus Forest Service, a Ninth Circuit panel held over a dissent that the 2004 EIS was indeed deficient. Among other things, it noted that the 2001 EIS had spent some 65 pages reviewing impacts on fish. By contrast, the 2004 EIS simply incorporated those pages by reference and did not otherwise add any new analysis, even though the 2004 EIS had recommended significant changes to the 2001 framework. The dissent complains that the majority ignored the tiering framework of different types of reports under NEPA and inappropriately recast the deferential, arbitrary, and capricious standard of review into a reasonable possibility rule that imposes new procedures not required by NEPA on the Forest Service. Now, I don't know anything about fish in the Sierra, and the majority's opinion might be the right one in terms of protecting the environment. But the dispute between the majority and the dissent over standards is sure to attract some attention from Supreme Court justices, which means this case stands a decent chance of snagging high court review. We had a second arbitration case in the Ninth Circuit. The federal Randolph-Shepard Act establishes a cooperative program between the federal government and the states to assist blind persons who wish to operate vending facilities on federal property. When certain types of disputes arise between the federal agency, the state agency, and/or the vendor, the Act provides for arbitration of those disputes. In Sauer versus United States Department of Education, a vendor and the California Department of Rehabilitation fell into a dispute with the Federal General Services Administration, which led to an arbitration award against the GSA and in favor of the vendor. But notwithstanding the Department of Rehabilitation's repeated efforts, the GSA refused to comply with the terms of the arbitration order. Counsel for the vendor then very cleverly demanded that the Department of Rehabilitation sue the GSA to enforce the judgment. And when the department refused, the vendor demanded arbitration of that dispute. In the second arbitration, the arbitrators decided that the department's refusal to sue was contrary to law, and made the department responsible for satisfying the damage component of the first arbitration award. The department appealed, and the Ninth Circuit held that the arbitrators had exceeded their statutory authority because the Randolph-Shepard Act does not impose a statutory obligation on a state agency to sue a federal agency for its failure to comply with a Randolph-Shepard arbitration award. So it would appear that the vendor and the department are stuck. They have a favorable arbitration award against the GSA, but apparently no way to secure judicial enforcement. Seems to be something's wrong with this statutory program. Next, we turn to a California Court of Appeal decision involving juvenile law. In In Re Gabriel K., we see a dependent child, two dependent children removed from their parents, and the court then refusing to grant reunification services. Now, usually, when a dependent child is removed from his or her parents' custody, the juvenile court orders that those services be provided to the family in order to facilitate its reunification. And that triggers a series of hearings every 6, 12, or 18 months to determine whether reunification is possible. However, reunification services need not be offered under certain circumstances specified by statute where it can be shown that the parent has not made any reasonable effort to treat the problems that led to the child's removal from the parent. In Re Gabriel K., the court declared the mother's two children to be dependent and denied any reunification services. Factually, the denial of reunification made perfect sense in this tragic case. The first of the children was born in 2001, and both mother and father were repeatedly in and out of prison and probation because of persistent drug use, where the children were regularly exposed to drug paraphernalia, drugs, and weapons. In fact, at the very time the mother was trying to contact agency employees about reunification, she refused to disclose her whereabouts because she was wanted by law enforcement. The appellate court affirmed the denial of reunification services based on the juvenile court's finding that she had made no progress at all toward alleviating or mitigating the causes for the removal of her two children. A tragic case indeed. Next, we have an evidence law problem. In People v. Gabriel, the defendant was convicted of cultivation and possession of marijuana and other offenses. He contended on appeal that the trial court erroneously admitted evidence of prior convictions for purposes of impeachment. The two priors were possession of an assault weapon and cultivation of marijuana. Now, subject to Section 352 of the Evidence Code, the California Constitution authorizes the use of any felony conviction which necessarily involves moral turpitude. Crimes involve moral turpitude when they reveal dishonesty, a general readiness to do evil, bad character, or moral depravity. The Second District concluded that both of the crimes in this case demonstrated a general readiness to do evil. Now, I think the court is stretching a bit on both of these. You can be found guilty of possession of an assault weapon in California, even if you don't know that it is an assault weapon. It is enough that you should reasonably have known it was an assault weapon. Well, that may show negligence, but how does negligence translate into a general readiness to do evil? And unless every felony shows a general readiness to do evil, how does a charge of simple cultivation of marijuana really establish bad character or moral depravity? My guess is the Supreme Court will leave this case alone anyway, because the Second District also holds in its opinion that even if these convictions were improperly admitted, the error was harmless in light of the evidence in the case, and that part of the appellate court's opinion is a lot more convincing. This particular opinion, I think, would be a good candidate for a depublication order to get rid of the overreaching by the court. And that's it for today's Kelso Report. Have a great day in the law.